Let's move on to other stories of the day. And mental health professionals and the Kenya National Commission on Human Rights have welcomed a judgment by the High Court declaring Section 226 of the Penal Code that criminalizes suicide as unconstitutional. They are now calling on the Attorney General to initiate the process of repealing the offending provision and relegate it to the past. Olive Barrows has more.
Charity Muturi battled suicidal thoughts from the age of 14 into adulthood. She died just 2 months before she won the battle against the criminalization of attempted suicide in a petition filed together with the Kenya National Commission on Human Rights and the Kenya Psychiatric Association. Muturi, having persuaded the court through her lived experience that attempted suicide is a product of mental illness and penalizing the sick with up to 2 years in jail deters them from asking for help and receiving care.
When you're dealing with somebody who is attempting to die by suicide, then this is a mental health issue. And so when you make it look like a crime, then you're preventing this person from seeking the help that might have helped them not engage in that kind of activity in the first place.
On Thursday, High Court Judge Lawrence Mugambi declared Section 226 of the Penal Code, which criminalizes attempted suicide, unconstitutional. A decision, the court observed, that was in tandem with Section 2 of the Mental Health Amendment Act and the Ministry of Health policy, that persons who attempt suicide are in fact victims of mental illness and not criminals who possess the requisite mens rea to commit this offence. Justice Mugambi, finding Section 226 of the Penal Code offends Article 27 of the Constitution by criminalizing a mental health issue, thereby endorsing discrimination on the basis of health, which is unconstitutional. He also found that it violates Article 28 on dignity, as it disgraces victims of suicide ideation in the eyes of the community for actions that are beyond their mental control. Lastly, he found it exposes victims to possible reprisals, thereby eroding the right to have the highest attainable standard of health as envisaged in Article 43(1) of the Constitution.
If a person is arraigned before the court pursuant to that statute, they will be able to raise a preliminary objection and say this is an unconstitutional and court-declared unconstitutional statute, but it needs to be repealed.
It is, however, worth noting that Parliament is one of 2 interested parties who opposed the petition on the grounds that it is Parliament that should have been petitioned, as it is the arm that wields legislative authority. And through the Clerk of the Senate, Jeremiah Nyengenye, Parliament made the case that the purpose of the section is to protect the sanctity of life and not to antagonize the rights of individuals suffering from mental health conditions. The Director General for Health, Patrick Amoth, also told the court that Parliament previously declined a repeal of Section 226 of the Penal Code in rejection of the recommendation of the Presidential Task Force on Mental Health. Olive Barrows, Citizen TV.